Okay, so there's a new case that just came out of the federal district court in Nevada, and it regards the uh, pause on immigrant visas for the countries listed, the 75 countries that were listed in the policy memo. The case is called Sangster versus Rubio. And ultimately, the judge ruled for the plaintiffs and said that essentially the Department of State cannot refuse to adjudicate these cases based on this policy. In the case, family members that were U.S. citizens had applied for immigrant visas or green cards for their family members in the Democratic Republic of Congo. And they hadn't had their interview yet, but they were suing because they were worried that if this policy was allowed to apply to them, that they wouldn't get adjudicated and they wouldn't get their green cards. So in ruling for the plaintiffs, I wanted to basically read the pertinent part of the decision. The policy essentially nullifies the grounds of inadmissibility that Congress created, and in particularly the public charge determination. Although the policy asks officers to go through the motions of an individualized analysis to determine whether the grounds of inadmissibility may apply, even if the officer finds no basis for inadmissibility, the result is still refusal. Congress set out a detailed statutory scheme that tasks consular officers with conducting a searching analysis of prospective immigrants' medical status, criminal history, financial affairs, and other personal details before admitting them. Although it could have done so, nowhere did Congress give the Department of State the power to make an end run around the categories of inadmissibility by refusing all applications by immigrants based on their country of origin. The public charge ground of inadmissibility specifically sets forth minimum and optional factors that a consular officer must or can consider in determining if someone is likely to become a public charge. The factors are meant to have an impact on the officer's decision. In making them redundant to the outcome, the Department of State has contravened the clear dictates of the statute. Basically, the judge is saying Congress has already made a law saying that these are grounds to deny someone an immigrant visa: criminal convictions, medical history, or likelihood that they will use public benefits. And what this policy is doing is saying you can just ignore that whole area of the law. Do not give these individuals immigrant visas. So the court is saying you can't do that. And if you want to do that, you need to change the law. You can't just put a policy out there. So while this only affects the plaintiffs in this case, it will be interesting to see how that type of reasoning can be used in possibly a class action case or other individuals that want to sue for their specific case. You can use that reasoning in your lawsuit, and hopefully other courts and other district court judges will agree. So stay informed. This is a great case that came out, and hopefully this will snowball into other people's cases and possibly class action. Take care.